150 metres of me.
No, they
okay?
don't.
Yes, they
No,
do.
they doesn't,
okay?
because the
Right, you will not be getting my details.
So if you refuse to provide those
Okay.
details, you're liable to be arrested.
You will not get my details. I'll tell you that straight, because
That's
I've
fine.
done nothing.
This is where the encounter shifts from a routine interaction to a statutory power being exercised under the Terrorism Act 2000. Section 43 is not a casual stop-and-search provision. It requires the officer to reasonably suspect that the individual is a terrorist, not suspicious behavior, not being uncooperative, not refusing to provide a name. The threshold is specific and legally significant. When an officer cites Section 43 without clearly articulating the grounds forming that suspicion, they risk acting outside the statutory framework. The law requires objective, evidence-based suspicion, something that could justify belief in terrorist involvement even at a preliminary level. If the grounds are merely filming in public or declining to provide personal details, that does not automatically meet the legal test. This moment sets the tone for the entire encounter. Either the officer can lawfully justify a counter-terrorism search, or the power is being misapplied, and that distinction carries serious consequences, both legally and procedurally.
For further search. I'll be searching today under Section 43 of the Terrorism Act.
Okay, right. Under Section 43,
Give me a
you
second,
need to give me the
second.
specific part of Section 43. Don't just give me a number. You need to give me the specific part, and also as well, okay, to do with actually having so-called evidence to use Section 43, you need to make sure that you get this done correctly, and you tell me what site, what actual part of Section 43. No, it will be an unlawful search.
You can make a complaint.
It will be an unlawful search.
And if you want to complain
And
about it,
if you feel that way, you can make a complaint
Okay.
afterwards. But this
So-
is what we're going to do here and now. If you have an issue with that,
what is your where is your actual proof of hostile reconnaissance?
we've explained to you.
Where is your proof of that?
at this moment in time, mate,
We don't
I
need
haven't
to-
even gotten to my grounds just yet.
So what is
As I
your
said,
no
I just-
no no? You're calling me a terrorist. You're doing
not
it under
calling you a
the
terrorist,
you're
I'm
doing it under the Terrorism Act. Is that, or is that not calling me a terrorist? If you were going to search me under the Terrorism Act, no,
No.
no. Right. Well, I'll tell you now. Please make sure that you quote me the specific part of Section 43 that you're going to do this under.
As I said, you'll be searched today
No,
under Section,
you need to make
Section
sure
43
that
of the
you
Terrorism
actually
Act.
give me the specific
The
part
reason
of
being-
Section 43.
The reason being why I'm searching today, sir, is because you're being
Here we see the officer attempting to justify the search by pointing to filming the back door of a police station and describing it as a bit suspicious. But suspicion in everyday language is not the same as reasonable suspicion in law. Under Section 43 of the Terrorism Act 2000, the suspicion must relate specifically to involvement in terrorism. Hostile reconnaissance can form part of that suspicion, but it cannot be inferred solely from lawful filming of a public building. UK case law and national policing guidance are clear. Filming in public is lawful unless linked to a specific criminal purpose. The officer's reasoning appears to rely on subjective interpretation, which is a bit suspicious, rather than objective intelligence or behavior indicating terrorist preparation. That distinction is crucial. If suspicion is based on feelings rather than facts, the legality of the search becomes highly questionable. This is a textbook example of how counter-terrorism powers can drift beyond their intended scope if not carefully applied.
will be searched today.
Okay.
As I said, the grounds being for the search is, because you've not really given us an actual
I don't have to
excuse as
give
why
you
you're
my
here.
name.
That's fine, you've been quite
Okay.
evasive towards us.
But I do
And
want
at
an
the
actual
moment in time,
sheet.
sir,
I do want an
that's
actual
fine.
sheet before I leave here.
That's
Okay,
fine.
of the search.
You're not letting me speak, sir.
Okay, because I
just
don't
want-
need to.
Okay, well, as I said, you've not really given us a reason as to why you're here.
I don't need to give you a
That's-
reason.
Let me speak.
Do I live in Nazi Germany? Do I live in
So
Nazi
you've not given
Germany?
us a reason as to why you're here.
What?
You've been
Well,
evasive
you've
towards
already
us.
said that it's because
You've
I won't give
also
you my
been
name.
quite obstructive at the
All
moment in
right.
time
Yep.
with the search.
Okay.
All right.
No, because I'm
And you've
questioning.
also-
I'm
you've
questioning the law.
That's fine. And also, the reason why we're searching today is because you've literally the only place that we've actually saw you search or film was the actual back door of a police.
Well, that
gate.
you've seen.
That's fine.
That you've seen.
Which is
Okay.
a bit suspicious, and that's why
Well,
I'm doing
no,
it.
no.
I
What
said-
you got to remember, that's your own feelings.
That's fine, sir.
That's your own
That's fine,
feelings.
but you-
Now the encounter escalates. The officer moves from a terrorism search to Section 50 of the Police Reform Act 2002. This power allows officers to require a name and address only where they reasonably believe a person has been acting in an antisocial manner. Antisocial behavior is legally defined. It must cause harassment, alarm, or distress to members of the public. It is not enough for police staff alone to feel uncomfortable. The belief must be reasonable and grounded in observable conduct that meets that statutory definition. If those conditions are not met, the requirement to provide details becomes unlawful, and any subsequent arrest for refusal would also be unlawful. This is a critical procedural turning point. The officer must now justify a second legal threshold, entirely separate from terrorism legislation. If that threshold cannot be met, the legal foundation for detention collapses.
No, they cannot.
Yes, they can. So as such,
Okay.
under Section 50 of the Police Reform Act 2002, I'm going to ask you to provide me your details,
Okay,
your name
right.
and address.
Now, I will
Hang on.
actually state this, okay? Under Section 50,
Yep.
okay, the Police Reform Act,
Yep.
okay, there has to be a member of the public within 150 metres of me.
No, there
okay?
doesn't.
Yes, they
No,
do.
there doesn't,
okay?
'cause the
Right, you
legislation-
will not be
the-
getting
the-
my
the-
details.
So if you refuse to provide those
Okay.
details, you're liable to be arrested.
You will not get my details.
In this final exchange, we see discussion around whether the use of the word turd constitutes a public order offence. Under the Public Order Act 1986, particularly Section 5, words must be threatening or abusive and likely to cause harassment, alarm, or distress. Crucially, the threshold is not about whether language is rude or insulting. It must meet a legal standard. Courts have consistently held that police officers, by virtue of their role and training, are expected to exercise a higher degree of tolerance when on duty. Case law has established that officers are unlikely to be considered victims of harassment, alarm, or distress solely by virtue of mild insults during operational duties. Therefore, suggesting that a minor insult automatically constitutes a public order offence risks overstating the law. This moment highlights a recurring issue in police encounters: the difference between offensive language and criminal language. The law protects free expression, even when it is impolite, unless it crosses a clearly defined statutory boundary.
Okay,
I've
you're
had
a
an
turd
offer
as
of
well.
£1,500 which has been declined.
Yeah, I am filming it.
So, and I
No,
will
I'm
see him
not.
in court.
No, I'm not. Tell me how a turd is a public order offence.
Well, you're causing me harassment and I would stress.
You can't be while you're on duty.
Oh, yes, I can.
No, you can't be.
Oh, yes, I can.
No, you can't be. Well, if you want to try it any further, then go for it. Go for your life.